In Oregon, victims of domestic violence can go to family court and obtain a specific restraining order against their abuser. These are known as Family Abuse Prevention Act orders, or FAPA orders. I'm Hansery LaForest, the Oregon Family Law Guy, here to present to you 3 things to know about Oregon domestic abuse and FAPA orders. As always, this isn't legal advice. Similar to other parts of family law, these proceedings and orders can get really complex. So if you need legal advice for your specific situation, stop and consult with an attorney. These are just helpful guideposts to help you understand what goes into how a court decides FAPA orders. With all that said, let's explore 3 things to know about Oregon domestic abuse and FAPA orders. Number 1. What's required to get a FAPA order? FAPA orders require 3 things. First, the person applying for the order, or the petitioner, must be the victim of abuse in the past 6 months. Second, the petitioner must be in imminent danger of further abuse. And third, the person against whom the petitioner is seeking the order must present a credible threat to the petitioner's physical safety. The petitioner and the other person, sometimes known as the respondent, must be either family or household members. They can't be strangers. But family can include former spouses, adults related by blood, marriage, or adoption, persons who have or are cohabitating, and persons who have been involved in sexually intimate relationships within the past 2 years. The second thing to know is the timeline of the FAPA process. When a person files for the FAPA order, they'll present the paperwork to the judge at an ex parte hearing. An ex parte hearing is a hearing where only the petitioner and the judge, but not the other party, is present. The judge that grants a FAPA order will look at the paperwork the person files, which is called the petition. The judge will make sure that the petition has specific and detailed information about an incident in the past 6 months before granting that initial order. If the judge grants the initial order, a copy of that order will be served on the other party. For that other party, the respondent, that person has 30 days to challenge the order and request a hearing. If the person doesn't formally challenge and request a hearing, the order goes into effect full-time as a matter of law. FAPA orders can last up to 1 year and may be renewed under certain circumstances. The third thing to know is that FAPA orders can have various effects. FAPA orders can include a restraint order, in which it directs a respondent to not intimidate, molest, interfere with, or menace the other person. They can have a no-contact order, directing the respondent to have no contact with the petitioner. This includes any communications, such as calls, emails, or text messages. It can restrain the respondent's access to other areas where the petitioner will be, such as work, school, and other places. And if the respondent and the petitioner live together, it can have an ouster provision, ordering the respondent to leave the residence. The benefit for the petitioner is that if the other party is caught violating any provision of the FAPA order, that is an offense for which they can be arrested and prosecuted. While FAPA orders are not criminal and won't give the respondent a criminal record, they are a matter of public record, meaning police, jobs, background search companies may be able to discover them. So it's important to treat these very seriously. And that's it. 3 things that you should know about Oregon FAPA orders. If you have further questions or need additional information, feel free to follow the link posted below. Thank you.